Good afternoon, everyone. My name is Alexis Alvarez. I'm the Director of Statewide Training at Florida Legal Services. Happy Friday. Thank you all for joining us on a Friday. I know it's always fun to have some trainings on a Friday afternoon. So we're very happy to be here in community with you and very thankful that you're here in community with us. So officially, I'd like to welcome you to the Intersectionality of Tax, Business Entities, and Dissolution of Marriage for Legal Aid Clients. For those of you who have been along this journey, this is a final installment of a training series that we've had dedicated to these three topics. Early in March, we had a webinar focused on tax issues. In April, we had a webinar focused on the business entities aspect. And this is, really the bow on the present. They're tying the bow on the present, putting it all together, bringing in, our tax issues, our business entities issues, and looking at it from that context of dissolution of marriage and family law. So I hope you all are just as excited as I am to be here. With that being said, I'm going to go into some housekeeping announcements. First and foremost, this is approved for CLE credit. We always like to get our CLEs. And at the end of this webinar, I will put the CLE code into the chat. I'll also say it out loud, but please always remember, you can always reach out to me if you don't get it or you miss it or things going too fast. I'm going to put my email address into the chat as well. And you can feel free to email me for anything that you need, any questions about CLE credit or the recording or generally about the training. Which brings me to my second piece of housekeeping announcements. Recording. This is being recorded, and a copy of this recording will be sent to everyone who is registered 24 hours after the event. That email will come from Zoom. So if you're searching your inbox for an email from me, you won't see it. It will come from Zoom. So check your spam, look, how those emails are. They're a little finicky. But as always, I'm going to put my email into the chat. And if you don't see it, or if you don't feel like looking for it, that's okay. You can email me and I will send you the recording directly. Finally, I want to give a housekeeping announcement about questions and answers. On our trainings, we always like to hear from our audience, answer those questions. I know it's hard in the virtual world to feel connected. So, please know that we want to hear from you, and you can drop your questions into the chat or the Q&A. And the way that this presentation will be structured is our first speaker will speak and talk about their topic, and we will stop and be able to ask questions, or if there's something burning that you just want to put in, that needs to be addressed in the moment, I will interrupt our speaker at the right time and ask your question. And that will be the same for the second half of the portion of the training. So just drop them in, and if they're burning, I'll ask them, and if not, we'll answer them after that speaker is finished. I hope all that makes sense. You all know I like to talk a lot. And with that being said, I'm just going to move into introductions so we can get started on the content. First up today, we are going to have Francois Blanco, who is an assistant professor of tax clinic and assistant director of student affairs at St. Thomas University College of Law. Professor Blanco is the assistant professor to the tax clinic, assisting low-income taxpayers with compliance and controversy matters against the Internal Revenue Service. He is also the assistant director of student affairs, assisting students in their law school journey. Previously, Professor Blanco advised high net worth individuals and multinational families in the areas of international compliance and tax planning. He advised clients in the creation, operation, and liquidation of their businesses. Professor Blanco also provided estate planning solutions to families in Europe, Central, and South America. Professor Blanco represented clients in front of the Internal Revenue Service and the Florida Department of Revenue with personal and business tax controversies. Today, we also have Miguel Cordona, who is qualified representative at the Low Income Taxpayer Clinic for the Legal Aid Service of Broward County and Collier County. Miguel Cordona is a qualified tax expert, and in that taxpayer clinic, he provides free legal assistance in the tax-related areas to eligible residents of Broward County and Collier County who are low-income taxpayers. While in law school, Miguel engaged in the Restorative Justice Project and volunteered as an assistant corporation counsel with the City of Chicago Department of Law and the Cook County Law Office of the Public Defender. He has also represented non-citizens in removal proceedings before the Chicago Immigration Court. Miguel holds a law license from the state of Illinois and is admitted to practice before the United States Tax Court. So with that being said, thank you both, Professor Blanco and Miguel, for being here and sharing your knowledge with us. The floor is yours.
Thank you, Alexis. Good afternoon, everybody. Welcome, and thank you for having me here. I look forward to giving you a quick informative presentation on business issues in the context of a dissolution of marriage. So bear with me. So to get it started, a few things. Today, the presentation itself is going to cover various areas in terms of the different types of business entities that we want to take into consideration, as well as the issues relating to those entities themselves. So the first starting point that we have is just discussing the concept of the business entities that are applicable or generally seen with respect to a marriage and their benefits in that sense. So starting off, our most common and generally accepted business entities in the United States are the ones listed here, which are sole proprietorships, corporations, limited liability companies, and partnerships. Keep in mind that when we're talking about a business entity, we're talking about two things. We're talking about the tax aspect, and we're also talking about the legal aspect. So this chart here demonstrates that legal aspect in terms of the limited liability protection that that entity gives or provides to a person, right? So as we all know, a sole proprietorship does not provide any limited liability protection because that's just an individual operating in their own capacity. So for instance, here where we have the spouses as sole proprietors, we have spouse one and spouse two who are just running a business operation in their own individual name. We have a circumstance where that business operation, just for sake of clarity, let's assume that they have a flower shop or that they are selling some sort of product. It's more than likely the income is coming into their own personal bank accounts. There's no differentiation between what's personal and what's business. Generally, they're operating in their own individual name. They could potentially be operating as a DBA, which is doing a business as, but other than that, they're operating in their own individual capacity. There's no limited liability protection because there's no entity, right? Here, there's spouse. If there's an issue with the business operation, spouse one and spouse two are both have unlimited liability associated with that entity. The next entity would be corporations. And with respect to corporations, uh, this one, with a corporation, you do have limited liability protection to the extent that you can maintain the formalities of that corporation. Formalities including you have a shareholder agreement, you have minutes, you have board resolutions, you have articles of incorporation. And in that sense, you have a business operation that's operating, but now it's held under its own entity name. So for instance, let's suppose that you have a flower shop again. Now it's instead of operating, flower shop by spouse one and two, it's now flower shop being operated under Flower Co, right? Flower Corporation. So in this instance, you have a corporation that's effectively generating the income and managing everything associated. The corporation itself has its own separate personal corporate bank account, and you're either seeing spouse one or spouse two receiving some sort of wages or salary from the corporation, or if they're taking distributions from the corporation, they're taking a dividend. The limited liability company is our third option. A limited liability company is a bit of a combination in terms of the limited liability protection. Here you're operating in the same, now you're still operating under an entity. Now, instead of it being a corporation, you are designated as an LLC. So for instance, now Flower Shop operation is operating under Flower LLC. And spouse one and spouse two effectively are members of this LLC. The LLC will generally have their own separate bank account and it will operate. All the income and expenses will flow from that account. And then subsequent to that, you generally have distributions from the LLCs out to spouse one or two. LLCs can usually be member managed or manager managed. And this is an important context when it comes to spouses who are working together. If you have a manager who's designated as the managing entity of that LLC, the members, in this case, spouse one and spouse two, don't really have a say in what's going on in the day-to-day operation. However, if you have a member managed LLC, you start having an issue where the members are deciding what is happening with respect to the operation of the business. Generally speaking, any income that flows into the LLC will automatically flow through to spouse one and spouse two. We'll discuss that a little bit further. But generally, that's how an LLC would work in that sense. Again, you have limited liability protection. Now, with a partnership and LLCs are very similar. In this instance, instead of you having members of an LLC, you now have partners of a partnership. And again, this is just a different state designation with respect to an entity. Each state will govern the benefits and detriments that each entity has. But regardless of that fact, each one is very different. So again, business operation, now you're operating as a partnership. So you have business operation LLC at that point. I'm sorry, partnership at that point. And to maintain the formalities of that entity, you need to have a partnership agreement. And of course, there's various types of partnerships, including general partnerships, limited liability partnerships, and limited liability limited partnerships. Each one of those levels of partnerships have different levels of limited liability, with general partnerships generally not having any sort of limited liability protection to the partners. And then with each level of the LP, LLP, and LLLP, you start having more of a liability protection between all of them. So again, in reviewing everything, we're looking at the business entities from just the state perspective. So here we know that from the state perspective, their legal benefits, a sole proprietorship has no limited liability protection. A corporation and an LLC do provide limited liability, and partnerships, except for general partnerships, do provide limited liability. Now that's on the state side. On the tax side, we have to understand that just because we have a state designation of an entity does not necessarily mean that that is also the tax profile that that entity has with the IRS. The IRS permits an entity to elect to be able to have different type of tax classifications and be treated very differently from its state nature based on the taxation that it needs, right? And oftentimes the planning associated with this depends on whether that entity is going to be used as a holding company, whether that entity is actually going to be operating, whether that entity operating in the sense it's actually going to manage businesses and have employees and have an actual income stream and expenses, or whether it's going to be used as an asset protection vehicle that's just going to hold assets. So we're going to go a bit through them in that sense in terms of defining which one is which, right? So the tax profile, you usually have a default classification. So for sole proprietorship, you have the tax profile is just at the individual level, whoever is the owner of that entity. The corporation, you can start off as a corporation or make an election to be treated as an S corp. If no election is made, you're automatically treated as a corporation. For a limited liability company, if you have just one owner, you're treated as a disregarded entity and you're treated predominantly in the same fashion that you would be as a sole proprietorship. In a partnership, I'm sorry, when you have multiple owners, like you would have in a husband and wife situation or spousal situation, you will be treated as your default classification being a partnership because for tax purposes, the concept of an LLC, if you have multiple owners, you're treated as a partnership. From that basis, you can elect to be treated as a C corporation or an S corporation, but that's an election that you would make with the IRS. And lastly, when you have a partnership, your default classification is a partnership, and of course, you can make an election to be treated as a C corp or an S corp. So this is where sometimes you might see an LLC. You might look at documentation and see that ABC LLC is completing an 1120, which is a corporate income tax return. And the reason that is done is because that entity has filed an election to be treated as a C corporation. Or vice versa, you might have ABC LLC that is filing an 1120S, which is for the S corporation. And that's because it was treated as an S corp. And now they need to issue out K1s and do that whole process. So keep in mind that with respect to entities, you have on one side the state aspect in terms of the limited liabilities and maintaining the formalities and assuring that we have the resolutions. that from a legality standpoint, that needs to be maintained to make sure that the entity is respected. But from a tax profile, you're looking at how that entity is actually being effectively taxed by the IRS. And you have default classifications, but you can always make elections to be treated as a different classification. So now we're going to go in and discuss what each one of these look like in terms of the tax profile, and then we'll jump in into looking at the issues associated with divorce. And it's important to understand these just because it makes the issues a lot more understandable in terms of the divorce aspect. With respect to disregarded entities, keep in mind that whatever net profit that entity has goes straight through to the taxpayer. What does this mean? Let's say this LLC were to generate $100,000 in net profit. That net profit would go on on spouse's one tax return on a Schedule C, and it would be taxed at the taxpayer at spouse's one's level. The LLC itself would not pay any taxes. Actually, for tax purposes, the entity does not exist. So it goes straight through directly to spouse one or spouse two. At the partnership level, we have, to the same extent as we did in the LLC, for income purposes and the way that it flows up, the income will flow up to directly to the spouse one and spouse two and be at their own individual level. But the partnership itself will not be disregarded for some aspects. So for instance, if I'm receiving income from the partnership, that income will flow through and the partnership will be treated as transparent, meaning it doesn't exist. However, if I were to sell my partnership interest or I were selling an asset in that partnership, or for any instance or another, I have a new member coming in, then at that point, from a tax perspective, the partnership does exist. And we're looking at a position where we need to understand what is our relationship between the partners and the partnership entity itself. But generally speaking, for income and expenses, it's treated the same way as an LLC where everything flows through. A corporation. So a corporation is effectively subject to two levels of tax. If you're an owner of a corporation, you're going to be subject to two levels of tax. The first one being the corporate income tax return, and then the second one is when you're paying a tax on the dividends that you're receiving. So again, let's assume that you have a corporation that generated $100,000 at the end of the year. That corporation is going to pay a corporate income tax. That corporation is going to file their own return, and that return, they're going to have to pay that 21% tax. Now, if the corporation issues a distribution out to the owners, or in this case, spouse one or spouse two, then that spouse will also need to pay a tax on that dividend, which ranges between 15 to 20%. This is very different from the first two, where here the LLC does not file a tax return. The partnership files what is known as an information return, just to let the IRS know what are the attributes that are being distributed, but not necessarily pay any tax. Here with a corporation, we have an entity that is actually paying a corporate income tax return, right? And then of course, here, if you do some quick math, you're roughly, if you're at the highest tax bracket and you have 100,000 or a million or whatever you want to make it, add more zeros to it, you get bumped up in brackets. You're effectively paying about 41% of tax with respect to the income that's being generated from the corporation. Here in this instance, if you're taxed at your individual level, you're looking at a 39% top bracket with the additional 3% for the net investment income tax, right? So each one of these are similar in terms of their tax attributes, but again, these are all different tax profiles that you take into consideration to determine their effect. And lastly, we have an S corporation. So many people get this confused thinking that an S corporation is a type of an entity. It is not a type of entity. The entities are just sole proprietorship, corporation, limited liability companies, and partnerships. An S corp is just a tax election. So they're not an entity by itself. It's not like you can create an S corp with the state and then have limited liability protection. That doesn't exist. You either created one of the three entities, a corporation, an LLC, or a partnership, and then elected to have one of those be taxed as an S corp. So keep that in mind. When you have an S corp election, it's effectively you're combining the benefit of a corporation and a partnership, which S corps were. If you're in the business realm, you'll know that LLCs are kind of novel in terms of their development at the state level. This is a type of entity that effectively models a structure of combining the benefits of a corporation with a partner, well, a corporation with a partnership. But before LLCs came into existence, the S corp, from a tax perspective, is what managed that a little bit more. And from a tax perspective, it combines both the benefits of having a corporation with the benefits of having a partnership. And in this instance, you'll see that it replicates the partnership concept a little bit more from a tax component. If you have income being generated by the S corp, that income will flow directly through to taxpayer to the owner, spouse one and spouse two. But it permits for some sort of planning with respect to wages and income, which aren't within the scope of this presentation, but it's really the S corp is really associated with that type of planning to assist with the wages, to do planning specifically with the FICA tax and the wage and income tax. So given that this tax profile is very similar to that of a partnership, uh, for the purpose of this presentation, that's all that's needed to be known. But it goes more in depth. It combines both the corporation and the partnership itself. So in that sense, jumping into now our divorce issues, right? So what are common business issues associated with the dissolution of marriage? First is the distribution itself, whether you are doing an equitable distribution, determining how the assets are going to be distributed, and whether you're in a a community state where property is automatically allocated between the two spouses. That's usually the first issue. The second issue is valuation issues. How do you value a business? If I have a stock in a publicly traded market, it's very easy to value my business. I just go and look at the stock market and see where that stock is at. But if I have if I have what is known effectively a private business, something that's not publicly traded, how do I value the interest or the ownership that I have in that asset or in that stock, right? I could potentially own a tire company, two spouses could own a tire company that is generating $10 million dollars a year. But then you're looking at a situation as to, well, if it's 50-50, 60-30, and then even determining that ownership, determining what the value is allocated to each one, right? As well as with valuation issues, and you need to look at the value of the assets, the value of the operation itself, and as well as any debts that are within the issue. Hmm. The third issue has to do with taxes and effectively transferring the assets between one spouse to the other. And that's always an issue depending as to when it needs to be done, how it's going to be done. And then keep in mind that spouses at this point are not on the best of terms, so they might not be too inclined to be cooperative with one another. So making tax issues could become something that can affect the business itself during a dissolution of marriage. Operation and management issues, that's always a big one. For instance, with the LLC, as I previously stated, an LLC can be member managed or manager managed. If you have a manager, great. That manager continues operating the business like there's no issue. Uh, if it's member managed and you have both spouses who are operating the business, that now becomes an issue as to who's making the decisions in the management. Um, for instance, let's assume that due to a dissolution of marriage, the management is not operating to its most, the manager or the person who is doing all the management, the member, doesn't put their full faith and effort into the business anymore. So it's not operating. So now it's losing value. And all this because of the dissolution of marriage, right? So these are all, that's a concern that could be from one part or the other. In a corporation, you usually have a board, but if that board or that officer, the CEO, the CFO, the CMO, they're all within that same two people, you kind of have those similar concepts as well. And then you have third party issues, which is where you're assuming that, let's say, business ownership could be between two spouses, or it could actually be with one spouse having full ownership of an asset or of a business, and another spouse not having any ownership at all. In a divorce, where you're looking at the distribution, if that spouse that's an owner of a business is operating with other owners, those other owners may not necessarily want to have an ex-spouse be an owner of that entity if everything gets distributed out in a in a dissolution, right? So those are generally the common issues that are seen with respect to effectively distributing business assets in a divorce. So looking at equitable distribution, you have two systems of property ownership in the United States: community property and equitable distribution. In Florida, we use equitable distribution, which is effectively governed by Florida Statute 61705 subparagraph A through J. And you're looking at various determinant factors. So, what does equitable distribution means? It's distributing based on equity, right? Meaning how much effort was brought in by both spouses, what assets did each spouse have. It's a very facts and circumstance driven analysis. Generally speaking, you can start off at the 50-50 starting point, and then you start adjusting based on all the other factors or circumstances as demonstrated here within. But really, it's really governed by what's defined within the divorce proceeding, right? Some things to consider are the contribution that each spouse has had into the marriage, the economic circumstances of each spouse, the duration of the marriage, interruption to careers and educational opportunities, contributions of one spouse to the career and educational opportunity to the other spouse. Um, the big one is the desirability of retaining any assets, including an interest in a business, corporation, or professional practice. This is always an important one. Just because you can distribute or divide a property, a business interest equally, doesn't mean that it's most apt to do so. For instance, imagine a situation where you're an owner, you're a lawyer who has a law firm, and you're going to distribute, and you're going through a divorce. Unfortunately, you can't necessarily distribute 50% of that law practice, because to have a law firm, you need to be a lawyer. If that spouse is not a lawyer, you can't really do that distribution. So those are things to also take into consideration. Here you have the contribution of each spouse to the acquisition, enhancement, and production of income, the desirability of retaining a marital home, that's always an important one, dissipation of assets, and any other factor applicable. So given those issues, those factors, you start to take into consideration as how that distribution is going to occur. And if you have one spouse if both spouses are contributing equally to the business, it can become a very complex determination in that sense. Here we have the definition of what are marital assets and liabilities, and a little bit is more just to give an idea of what would be considered a marital assets. Anything just very, very simplistic. A marital asset is effectively anything that's owned singularly and has not been put together or participate in the marriage itself, right? So to the extent that, let's say, I own a business in my own individual capacity before getting married, but now I'm in a marriage and my spouse has now assisted me with that business, that now has become a marital asset, even though prior to that it was a non-marital asset to that extent. So keep in mind that assets may at one point be considered non-marital assets, but to the extent that now you have both parties in a marriage participating within that same asset, enjoying its use, its benefit, have generate or acquire any sort of vested rights associated with that asset, it will become a marital asset subject to equitable distribution. So going through this, so let's look at the tax implications. With respect to transfers of assets, you're looking at two things: the income that's being generated from that asset, and then the tax consequences of transferring that asset. In tax terms, it's being defined as what's the income tax on the income, and then what's the capital gains tax on any sort of transfers. Income tax is governed by Section 71. The transfer of the property is governed by Section 1041, these are sections of the Internal Revenue Code. The Tax Cuts and Jobs Act of 2017 struck down Section 71, which had to deal with alimony. And alimony is effectively in part of a divorce proceeding. If you had one spouse paying alimony to the other one, the spouse paying the alimony could take a deduction with respect to that payment, and the spouse receiving the alimony would effectively be including that in income. The Tax Cut and Jobs Act of 2017 struck it down, and now those you don't include it in income, and you don't receive a deduction for it, right? So a lot of things that occurred at that point in time was that you had various divorce instruments that were modified after the fact to make adjustments with respect to the alimony, just because it no longer made sense to maybe have a higher alimony, which gave you a higher deduction, or maybe it made more sense to ask for a higher alimony because it didn't affect your income, right? So that started to occur a lot during the 2018-2019. Keep in mind that the TCJA is coming into effect under 2025. It is until 2025 unless it gets extended. So there's a potential for it to come back. However, as currently stated, we have these qualified divorce instruments. We have the Section 71 struck with respect to the alimony itself. Subsequent to that, we're looking at transfers of property, which alimony, Section 1041 applies to the transfer of property itself. So think of it as real estate, cars, stock, membership interest, business interest. These are properties that are not tangible as cash, but are still need to be transferred between the parties, right? Where Section 71 deals with cash payments, 1041 deals with the transfers of property. And 1041 is split up into a few subsections, which we'll go through it now. So keep in mind that 1041 permits for spouses to transfer property between themselves tax-free, right? It wouldn't make much sense if I came in and I tried to transfer a house or a car or any sort of assets to my spouse, and then my spouse comes in and gets taxed on it, or I get taxed on it, because it would just impede that transfer. That's the first rationale behind it. The second is that from a tax perspective, the tax code views spouses as one tax unit. So ideally, let's say me transferring assets to my spouse is effectively like me moving money from one pocket to the other pocket, right? So that's a bit the rationale behind 1041 and why transfers between spouses are generally tax-free. So it becomes, with respect to 1041 applies all the way where you have spouses, you get married, but it also applies to the extent that you are recently divorced, right? So for instance, Section 1041 applies to transfers between former spouses if the transfers are incident to a divorce. And here, a transfer is incident to a divorce if the transfer occurs not more than 1 year after the date on which the marriage ceases, or the transfer is related to the cessation of marriage. So in this instance, you're looking at a situation where you have recently married people who have gone through a divorce. You have up to 1 year after the divorce for 1041 to apply and have a tax-free exchange between properties. Why is that important? Because if I have business interests, let's suppose my business is holding real estate, and I'm just collecting rent, and I have, let's say, 100 units of real estate, and I'm collecting a good amount of income coming in. If I purchase all that real estate at a cost of, let's say, $1 million, and now it's worth 5 million, you have an appreciation of 4, and that appreciation of 4 million is something that would be subject to tax at 20% tax rate, which would be, could be a $1 million tax liability. However, we're trying to allocate that between former spouses, and we do that within that 1 year period. We can minimize the impact between both spouses and assure that they don't have that effect, right? That they don't have that costs associated with that transfer, at least within. Now, this rule is it's like a bright line rule that's not so bright, meaning that just because if you're within the year, you are definitely going to fall within the rule. There are certain circumstances where you can extend beyond that 1 year mark, but it really needs to it really needs to occur due to extenuating circumstances, where maybe you had a divorce issue, but for some reason, or you finalized your divorce, but then subsequent to that, for some reason or another, the transfer didn't occur 2 to 3 years down the line just because of practical or extenuating circumstances. 1041 could still potentially apply, but keep in mind that the rule itself is within a year. And then this only 1041 only applies to transfers that occur between spouses themselves, spouse one with spouse two. It does not apply to a circumstance where you have spouse one and spouse two that holds an asset and then sells it to a third party. That is a normal sale, and that does not fall under section 1041. So keep that in mind. Section 1041, and of course in tax you have a rule and then you have an exception. And then this is an exception to the last rule where you have sales to third parties. Section 1041 may apply to third parties if the transfer to a third party is made by one spouse on behalf of a spouse or former spouse to a third party because they are in substance between the spouses. So this occurs not when we have spouse one and spouse two selling an asset to a third party, but let's say have spouse two who owes a third party some money or has a debt with that person, and then spouse one transfers an asset to that third party to satisfy that debt. That kind of transfer would fall under 1041, even though it was a transfer done to a third party and not between spouses. Okay. And then lastly, we're talking about stock redemptions. This is something that applies very particular to corporations because corporations are the only ones that have stock redemptions since they have stock. And a redemption is effectively a technical term to explain when I'm returning all of my stock to a company to receive some sort of property back. It could be either cash or property itself, and I cease having an ownership interest. So to the extent where you have a spouse that's an owner of an entity and you want to liquidate them or seize their ownership interest, you could potentially have a redemption. And in that sense, if you're looking under 1041, you could do that process as well and have it fall under the 1041 scope, even though it's more of like a corporate activity that's being done at the corporate level. Let's see, transfers that are outside the scope of 1041. The first one would be section 1041E requires a transferor to recognize gain to the extent of liabilities and to the extent that liabilities exceeds the adjusted basis of property. So this applies to the circumstance where we have a property that was originally purchased, let's say for $1 million, and 800 of that was a debt, 200 of that was own principal property, capital. And then let's say at the point of it being transferred, the value on that property came out to be 500,000, right? So the value that's being transferred is less than whatever debt was originally taken. You would at that point recognize 300 of debt as income and would have to pay taxes on that. So those are a little bit of the circumstances where you would want to go with a tax advisor or at least spot the issue, and knowing that if you're going to transfer assets between spouses and there's some sort of debt and the value does not exceed the extent of the liabilities or the property or the cost of the property, that you could have a very big tax consequence if not handled appropriately, right? So keep that in mind. 1041 does not cover those types of transfers. The second one has to do with installment agreements or installment obligations. Keep in mind that with respect to, in some circumstances, a divorce proceeding might require you, let's say that we were going to do some sort of equitable distribution, we can't split up a business 50-50. So what will often happen will be that a judge will come in and state, okay, this business is worth $1 million. You, spouse one, keep the business because you're the main operator, you're the one functioning, you're doing it perfectly fine. That's not a problem at all. But spouse one, you need to pay spouse two 500,000 in a lump sum, which would represent their 50% equity in the business. And you're effectively buying out the buying out spouse two. That type of large cash settlement, unless it can be paid at once, will generally be negotiated as installment payments that have some sort of interest tacked on to them. And here, installment obligations, to the extent that you are paying the installment itself, the payments that are being made as principal will fall under 1041, but the interest that's being paid on that principal will not. So the spouse that's receiving that obligation will need to recognize that income as part of gross income in that sense. So 1041 does not apply in that context. Transfers of installment obligations. This is quite a unique case. So here in Yankwich versus Commissioner, husband's business partner executed a promissory note in repayment for a husband's interest in their dental practice. The divorce agreement provided that the husband would pay over to wife a specified amount of each promissory note payment, with each payment to wife bearing its allocable share of underlying note principal and interest. The court held that the wife did not realize gain with respect to the principal portion of each payment, as contended by the IRS, because the wife had no beneficial interest in the note. Since the husband, not the wife, owned the note, the portion of the note representing principal was non-taxable to the wife. So, just as a bit of background, here we had husband sold dental practice, let's say for $1 million. Person who bought it didn't have the $1 million, so what they did is I'll give you 200, and then I'll give you a promissory note for the remaining 800. So husband at that point received 200 plus this note. So husband had been receiving payments from this third party. Husband goes through a divorce. Wife states, well, husband has this promissory note. Let's split that payment in half. He gets half, I get half. And at that point, that's the IRS had made a contention in this case that installment obligation did not fall in line with 1041. But here in this court, in this case, the court held that it did. So that those payments themselves, even though they were an installment obligation, they would still be considered as property being transferred between husband and wife. So at this point, wife does not, the portion that the wife is receiving of that principal is not taxable to her as a transfer of property. Which is very different. It's a transfer of property, meaning instead of splitting up the promissory note and having the third party come in and cancel the first note and then try to issue two notes with husband and wife, now we have a situation where the court is saying, well, look, from a divorce perspective, this promissory note has been split into two, with the husband recognizing a lot of the income tax on the entire receipt of the note, but then the other payment going off to wife and her not being taxed on it. So that's a bit, it's a wrinkle in all of these rules, but it's always important to know when you're dealing with obligations and settlements, that if you're going to have a payment that's going to be done over a period of time, you want to make sure to first document it as a promissory note or some sort of payment agreement, and then second, see what its tax consequences are. Keep in mind that 1041 does not apply to spouses that are non-resident alien spouses. So if you have a divorce proceeding between somebody who's a US person and somebody who's a non-resident alien, or effectively someone who's not a green card holder or effectively a US citizen, 1041 does not apply. So any transfers of assets will be taxable. Keep in mind that 1041 only applies to transfers that happen during marriage and 1 year after after a divorce, only if it's incident to that divorce. It does not apply to transfers that happen before marriage. So for instance, if I have a girlfriend and I transferred $1 million in assets to my girlfriend, I'm going to have to pay that tax on it, even though we might be living together, we might be cohabitating, we might be operating in that sense. If we're not yet married, Section 1041 doesn't apply, which is a very important concept here, because In common law jurisdictions, you may have or fall into line of being in a common law marriage. So that could be something that could, if you're living, cohabitating together, that could be something that could be taken into consideration. In Florida, you need to have an actual marriage. So that's always something to keep in mind. Assignment of income doctrine. So the assignment of income doctrine is a position that the IRS takes where they, just because two parties arrange a transaction to meet one way or the other does not necessarily mean that the IRS will respect it. And an example of this might be in a situation where, let's say, I am working for income, but I'm telling my employer, whoever's paying me that income, to pay it out to someone else. The IRS does not recognize that as a valid transaction, meaning they don't deem you to not, they don't deem you to not recognize that income. The IRS effectively deems you as recognizing that income and then effectively gifting it over to that third person, even though you might be doing the work, but the employer is paying that third person directly. The IRS does not permit you to assign your income, right? And that's what the basis behind the assignment of income doctrine, where even though you're the one that's conducting all the work, even if you want to come in and state, look, we're giving this income to another person, the IRS will not necessarily respect that, right? And again, it's a facts and circumstance analysis. It does happen a lot with respect to divorces because you're effectively you're transferring property to another spouse where the property is still in the name of one spouse, but the income that's coming to them is going to the other spouse. Then you have spouse one, who's the owner, who might potentially be stating, well, that income never came to me. Why am I being taxed on it? And then subsequent to that, why am I being taxed again on it? Hello? So that might be something that we might want to take into consideration.
Oh, Professor Blanco, we lost you for a quick second. I thought it was maybe just on my end.
Bear with me. Can you hear me now?
I can hear you. Miguel, are you able to hear Professor Blanco?
Yes, I can hear him now.
Okay, but the video is still frozen on my end. Is that the same for you as well, Miguel?
Yes, it is frozen.
Okay, Professor Blanco, maybe try turning your video off and on. It might recalibrate.
Okay, bear with me. Sorry for the technical difficulties.
Well, at least we can hear you now, so that's good.
Yes. Pardon me.
And if it's easier, you can proceed with the presentation with your video off. That way you're not just frozen on there. And then, at least we can hear you.
Of course, of course. For some reason or another, I think I might be having.
Okay, I can turn your video off. I should be able to, although that might affect your ability to share the screen. So maybe we shouldn't do that.
Yeah, bear with me. I think I'm having. If I move my slide, are you able to see my slides move?
Yes.
Oh, okay, perfect. So let's proceed on that, and let me see if I can, just because I'm getting a little technical difficulty here.
Yeah.
So in terms of the video, but yeah, if you could turn off the video, I think that would work.
Let's see if I can.
Okay. If not, then I can finish the presentation. We don't have much coming. We're about to close.
All right. Thank you so much, Professor Blanco.
No.
Thank you, everybody. It's a Friday, a wonky Friday.
Apologies for that. So, given that perspective, going back to the assignment of income doctrine, the IRS really doesn't like it when you're trying to assign your income away from you and avoid taxation. So that's always to keep in mind. And lastly, we're looking now at what are some possible remedies to do prior to, what are some things that can be done prior to a dissolution of marriage and then after the dissolution of marriage to make sure that all bases are covered. Prior to a dissolution of marriage, the one thing that can be done is if you have a business entity, you effectively have restrictions on how you're going to transfer those interests in that business entity from any person, right? And this is more in the agreement that if I have a corporation or an LLC or a partnership, the partnership agreement, the operating agreement, and effectively the bylaws of the company restrict how those transfers of interest and ownership are going to be done, especially in the case of a divorce, right? That could be your first part, where if you outline that in the instance that any owner were to get a divorce, the company effectively buys back that stock ownership interest and pays that spouse or pays that owner for that money, then that is a circumstance that gets handled right off the bat, right? So that's something that could be taken into account. The second one would be, and in addition to that, restrictions on transfers, you also have restrictions on management of the company, how the company will be managed, how it'll be operated. You can restrict it in that sense. The other part would be considered with spousal consents, where in addition to having the restriction in the governing document, you also have a consent from each spouse of the owner advising that they're effectively waiving any interest that they have in that business. And in the instance of a divorce between the spouses or the owner, that at that point they would treat that at that point they would effectively renounce all interest. So that effectively puts out a business interest out of any sort of divorce proceeding. And if there is, or if they become part of that divorce proceeding, the company itself, the operation of that company is not affected, and you have a mechanism on how to make that transfer outright. And then let's see, these were the spousal consents. And then after marriage, you definitely want to not, the big basis points is that if you have a business interest, you want to make sure that you have independent agreements.
Oh no, it looks like we lost Professor Blanco. We were so close to the end of his presentation. So let's see if he's able to log back in. And in the meantime, folks, I'll just take up some airtime and I'll say, if you have any questions, any thoughts, I know there's a lot of content that we're going through, but please feel free to drop that into the Q&A or the chat. As soon as Professor Blanco gets back on, I'm sure he will be able to answer those questions. And I know a question came into the chat about receiving the content and the slides. I will ask if Professor Blanco is willing to share the slides. And if he is able to, I will certainly make sure everybody gets those. So if everyone wants to take a little moment's break, I'm going to email Professor Blanco. And if he's not able to get back on, we'll move on to Miguel's portion of the presentation. You're back, Professor Blanco. We thought we lost you.
No, not at all. I'm back.
Fantastic.
Apologies for that. So with respect to the transfer agreements, you want to have an agreement that's separate from the marital settlement agreement, right? The marital settlement agreement is important just to outline from the family law perspective. This is how the assets are being divided. But to itself, if I'm dividing a business or we're relying on paying out someone a settlement for their interest in that business, you want to make sure that you have the appropriate agreements associated with just that aspect to avoid any issues down the line, right? In terms of if you're going to separate the interest, you want to make sure that you do an audit of the operation and the finances. You have an anti-fraud provision. You make sure that you have documentation documenting the transfer of the full interest and all inspections of relevant materials. You want to make sure that if you're going to have a clean cut, it's as clean as possible. And it's not just with the marital settlement agreement being the governing document, but having all these other related documents or agreements that document specific issues with it. You also, to a certain extent, want to have a release. Releases are important when it comes to business because as a business operation, you can have issues with taxes. You can have issues with fraud inside the company. You can have issues with employees. You can have issues with a lot of various vendors, customers, clients, a lot of liabilities associated with a business where if you're breaking away from a company, you don't want to have a lawsuit down 2-3 years down the line where they're naming you as a party because you used to be a former owner. So having a release agreement and an indemnification agreement is very important. And of course, a confidentiality agreement, right? So if you have a spouse that's been very actively involved with the operation of the business, you want to make sure that they maintain trade secrets and to a certain extent that they don't go after your clients or that they don't compete against you, right? So we're permitted these agreements would be supplemental agreements that you would want to have in addition to a marital settlement agreement to avoid having to just cover all your bases associated with that transfer. So with that being said, that's the conclusion of my presentation. I'd be happy to take any questions that you guys have.
Amazing. Thank you so much, Professor Blanco. So the questions that are so far in the chat are more logistical. Somebody did ask if they're able to get a copy of your slides. I know it's a lot of information, so folks probably want to peruse it on their own. Is that something that you're comfortable with? I know I'm putting you on the spot.
Yes, yes, that's no problem at all.
Awesome. So I'll touch base with you afterwards to get a copy of those slides. And the second question was about the CLE number. And I will post that CLE code into the chat for folks that have to drop off early. But we are continuing the presentation on to Miguel's portion. So please stay on if you have the time. That way we can listen to the rest of the presentation. Of course, if you have to hop off, you're going to get a copy of the recording, and that will include everything Professor Blanco just taught us and everything that Miguel is about to teach us. And as I was taking up a little airspace here, we did get a question. A question that we received in the chat was, why would one elect S Corp? Why would we see a change in the filing into S Corp?
So to explain that, to a certain extent, S corps became really big back in the 80s, 70s, and 80s and early 90s because a lot of states hadn't adopted the concept of what is a limited liability company, an LLC, which effectively when you made an S corp election, you kind of got that tax treatment. With the influx of LLCs, you now have a little bit more S corp. And now the S corp has become predominantly used for the basis of if you have a very let's say it applies a lot to a type of business, a service-based business that generates a high level of income, right? And the reason why that, imagine an attorney, an accountant, an adjuster, somebody who flips houses, anybody who's in a service business and is making somewhere above, $400,000, $500,000 a year. What occurs is if you're generating $500,000 a year, or let's say $1 million a year, you're subject to not just the income tax, but you're also subject to the self-employment tax. And the self-employment tax itself is an additional 15% tax. The S Corp allows you to plan for that 15% tax because it lets you bifurcate your earnings between what is effectively your salary and then what are distributions from companies. So imagine if I had no S corp election, I generate $1 million. I have $1 million, and then I'd have to pay my income tax and FICA tax on that million. With an S corp, I can tell the IRS, look, out of that million, 100 is my salary on which I pay my income tax, and then I also pay my FICA tax, and then the remaining 900 is just distribution that I pay my income tax. So that's really, in a very nutshell, avoiding a lot of detail, and exceptions. It definitely shows the main benefit of an S corp at this moment. I think you might be muted, Alexa. Sorry.
I am muted. That answer and that detail, goes to show you how the complexity when all of these things interact, right? So
Yes.
you're, you both giving us training on this. I can't express to you how wonderful it is and how needed it is. Another question did come in, and you received a thank you for that answer.
Oh,
Another
no
question
problem.
that did come in, was Professor Blanco. In a dissolution of marriage action, if the wife stays in the marital home until the child turns 18 years of age,
Mhm.
and then the MSA states that the property will be transferred to the husband upon the child turning 18, will the 1-year IRS rule then not apply? Just want to make sure I'm understanding it correctly.
So this is a circumstance. This is one of those extenuating circumstances where you would have a dissolution effectively if it occurs. Let's give the child an age of 5. So if the child is currently 5 today, that means 13 years down the line, the property will transfer over. I think at that point, the IRS might view that transfer as not falling under 1041, which is very unfortunate because even though it's part of a marital settlement agreement, the IRS will say that it's a transfer that happened beyond the 1-year rule. I've seen situations where the IRS has, or the court has ruled in favor of the IRS going 4 years, 3 years above the 1 year. So here it'd be 4 years in. 15 years in, I think it might be a little bit more difficult. But I think what you would want to do at that point, just to effectuate this, is now as part of your as part of the marital settlement agreement, you would want to make sure that you have a new deed executed on the property showing that there's a remainder to husband. Effectively put a condition on the life estate that you current, because that's effectively you have a life estate on the property for wife and child until the child has reached age 18, but the remainder is to the husband. And at that point, file that and do that within the 1 year mark, and that will effectively show the transfer of title, but still give the property rights to spouse and child. I mean, that's one way you can do it. There's various ways you can structure it that way, but that's the first one that comes to mind. And the person who would be subject to tax would there be the wife. Because if the wife is the one that's owning the home, well, it depends who has title and ownership to it, right? So if it's equal, then presumably, yeah, the person giving the property, the grantor, is the one that pays the tax on that. Oh, you might be.
And I will say before I turn it over to Miguel, that the person who asked that question said, "Thank you so much. This is one of the best presentations I've attended." So, Professor
My
Blanco,
pleasure.
thank you so much.
Thank you. Thank you for having me.
Of course, anytime. Please come back. Give us more. All right. And with that being said, with no other questions that I see in the chat or the Q&A, you're on the stage, Miguel.
Okay, thank you. So I will be presenting in the intersection of personal income tax in the context of dissolution of marriage. Can you see my presentation?
Yes, I can. It looks wonderful.
Oh, okay, great. First, I'm going to be speaking about the relevance of income tax in the context of dissolution of marriage, joint and several liability. Filing a joint return makes both spouses liable for the entire liability. This is known as joint and several liability. The liability extends to any additional liability determined by the IRS, even if the item belonged to the other spouse. The liability remains even if the couple divorces and the divorce decree states that the former spouse will be solely responsible for the tax. In some cases, a spouse or former spouse will be relieved from liability from a joint return. And to be relieved from liability from a joint return, there are 3 types of relief available. First, innocent spouse relief. Second, separation of liability relief. And third, equitable relief. I will be speaking first about the innocent spouse relief. Innocent spouse relief. A request for innocent spouse may provide for relief of responsibility for paying tax, interest, and penalties if your spouse or former spouse improperly reported items or omitted items on your return. The IRS may grant full relief, partial relief, or deny the request. For innocent spouse, there are certain requirements to obtain relief. First, you have to have filed a joint return. If there was no joint return filed, then this will not be the relief available, although the person may be eligible for a different relief. Second, there must be an understated tax on the return that is due to erroneous item of the other spouse. And you can show that when you signed the joint return, you did not know and had no reason to know that the understated tax existed or the extent of its existence. For actual knowledge or reason to know, you are considered to either knew or had reason to know of an understated tax if you actually knew of the understated tax, or a reasonable person in similar circumstances will have known of the understated tax. For actual knowledge, you're considered to actually knew of an erroneous item if you knew that an item of unreported income was received, you knew of the facts that made an incorrect deduction or credit unallowable, knowledge of the source of an item, of an erroneous item, is not sufficient to establish actual knowledge, and actual knowledge may not be inferred when you only had reason to know of the erroneous item. There are certain factors that support a finding of actual knowledge. The IRS may rely on all facts and circumstances in determining whether you actually knew of an erroneous item at the time you signed the return. The IRS will also consider factors such as whether you made a deliberate effort to avoid learning about the item in order to be shielded from liability, and whether you and your spouse or former spouse jointly owned the property that resulted in the erroneous item. There are certain exceptions for spousal abuse and victims of domestic violence. Even if you had actual knowledge and there is a finding of actual knowledge, you may still qualify for relief if you establish that you were the victim of spousal abuse or domestic violence before signing the return. And because of that abuse, you did not challenge the treatment of any items on the return because you were afraid your spouse or former spouse will retaliate against you. There is a difference between duress and spousal abuse or domestic violence. If you establish that you signed your return under duress, that is, under the threat of harm or other form of coercion, then it is not a joint return, and you are not liable for any tax shown on that return or any tax deficiency that the IRS may later find for that return. But you may be required to file a separate return for that tax year. Reason to know. For reason to know, if you had reason to know about an erroneous item that belongs to your spouse or former spouse, the relief discussed here does not apply to any part of the understated tax due to that item. In this situation, both spouses remain jointly liable for that part of the understated tax. Similar to actual knowledge, the IRS will consider all facts and circumstances in determining whether you had reason to know of an understated tax due to an erroneous item. Partial relief. When the IRS cannot grant full relief, they may grant partial relief. That's when only a portion of an erroneous item is unknown. You may still qualify for partial relief if, at the time you filed the return, you had no knowledge or reason to know of a portion of an erroneous item. You may be relieved of that understated tax due to that portion if all other requirements are met for that portion. For innocent spouse relief, the IRS will consider if taking into account all the facts and circumstances, it will be unfair to hold you liable for the understated tax. Lastly, the IRS will not grant innocent spouse if it proves that both spouses transferred property to one another as part of a fraudulent scheme. The other form of relief available is separation of liability relief. Under separation of liability relief, the understated tax plus interest and penalties is allocated between both spouses. Each spouse is generally allocated the amount that each spouse is responsible for. Under this type of relief, refunds are not allowed for any liabilities that have already been paid. To request separation of liability, you must have filed a joint return and meet either of the following requirements at the time that you request the relief. The first requirement is that you're no longer married to or are legally separated from the spouse with whom you filed the joint return for which you're requesting relief. And the second requirement is that you were not a member of the same household as the spouse with whom you filed the joint return at any time during the 12-month period ending on the date you filed the request. The burden of proof for separation of liability relief is that you must be able to prove that you meet the requirements previously mentioned, except the actual knowledge that is required for innocent spouse. and that you did not transfer property to avoid tax. You must also establish the basis for allocating the erroneous item. So you have to be able to indicate which items belong to the requesting spouse, the spouse that is applying for the relief, and for the former spouse or the non-requesting spouse. Limitations on relief. Even if you meet the prior requirements, separation of liability relief will not be granted in the following situations. The IRS proves that the spouses transferred assets to one another as part of a fraudulent scheme. The IRS proves that at the time you signed your joint return, you had actual knowledge of any erroneous items giving rise to the deficiency that were allocable to the other spouse, and there was a transfer of property to avoid tax or the payment of tax. The third form of relief that I will be discussing is equitable relief. If you do not qualify for neither of the previous forms of relief, innocent spouse or separation of liability relief, you may still be relieved of responsibility for tax, interest, and penalties through equitable relief. If you did not file a joint return, but did not qualify for relief from liability for tax attributable to an item of community income, you may be eligible for equitable relief. There are different rules for community property statements. That is not going to be covered in this presentation because Florida is not a community property state. Unlike innocent spouse or separation of liability relief, you can get equitable relief from an understated tax or an unpaid tax. An unpaid tax is an amount of tax you properly reported on your return, but you have not paid. And this is important because this is one of the main differences between the prior two forms of relief and equitable relief. Here, you don't necessarily have to have an understated tax to qualify for equitable relief. Even if you just have an unpaid tax, there is just an unpaid tax, you may qualify for equitable relief. For the other two forms of relief, there must be an understated tax. Okay, the conditions for getting equitable relief. To be considered for equitable relief from joint and several liability, you must meet all of the following conditions. You're not eligible for innocent spouse. You filed a joint return for the tax year at issue. You timely filed your claim for relief. There was no transfer of assets between spouses as part of a fraudulent scheme. There was no transfer of property for the main purpose of avoiding tax or the payment of tax. Conditions to be considered for equitable relief. You did not knowingly participate in the filing of a fraudulent joint return, and the income tax liability from which you seek relief is attributable either in full or in part to an item of your spouse or former spouse, or an unpaid tax resulting from your spouse's or former spouse's income. If the liability is partially attributable to you, then relief can only be considered for the part of the liability attributable to your spouse or former spouse. The IRS will consider granting relief regardless of whether the understated tax, deficiency, or unpaid tax is attributable in full or in part to you if any of the following exceptions apply. Exceptions for consideration of equitable relief when the item belongs to the requesting spouse. The requesting spouse is a spouse that is applying for the relief. Some exceptions are the item is attributable or partially attributable to you solely due to the operation of community property law. If you meet this exception, that item will be considered attributable to your spouse or former spouse for purposes of equitable relief. If the item is titled in your name, the item is presumed to be attributable to you. However, you can rebut this presumption based on the facts and circumstances. You did not know and had no reason to know that funds intended for the payment of tax were misappropriated by your spouse or former spouse for his or her benefit. If you meet these exceptions, the IRS will consider granting equitable relief, although the unpaid tax may be attributable in part or in full to your item, and only to the extent the funds intended for payment were taken by your spouse or former spouse. Conditions to be considered for equitable relief, this is a continuation. Some of the exceptions, additional exceptions, are that you establish that you were the victim of spousal abuse or domestic violence before the return was filed, and that as a result of the prior abuse, you did not challenge the treatment of any items on the return for your fear of your spouse's or former spouse's retaliation. If you meet this exception, relief will be considered even though the understated tax or unpaid tax may be attributable in part or in full to your item. The item giving rise to the understated tax or deficiency is attributable to you, but you establish that your spouse's or former spouse's fraud is the reason for the erroneous item. There are certain factors for determining whether to grant equitable relief. Some of the factors are marital status, economic hardship, knowledge or reason to know, unpaid tax, reason to know, abuse by your spouse, legal obligation, significant benefit, compliance with income tax laws, and mental or physical health. The first factor that I will be discussing is marital status. The IRS will consider whether you are no longer married to your spouse as of the date the IRS makes its determination. If you're still married to your spouse, this factor is neutral. If you're no longer married to your spouse, this factor will weigh in favor of relief. You will be treated as being no longer married to your spouse only in the following situations. If you are divorced from your spouse, if you're legally separated from your spouse under applicable state law, you are a widow or widower and are not an heir to your spouse's estate that would have sufficient assets to pay the tax liability, and you have not been a member of the same household as your spouse at any time during the 12-month period ending on the date the IRS makes its determination. For these purposes, a temporary absence is not considered separation if the absent spouse is expected to return to the household. You're considered to be a member of the same household for any period in which both of you maintain the same residence. Economic hardship. For purposes of this factor, an economic hardship exists if satisfaction of the tax liability in whole or in part will cause you to be unable to pay reasonable basic living expenses. If denying relief will cause you to suffer economic hardship, this factor will weigh in favor of relief. If denying relief will not cause you to suffer economic hardship, then the factor will be neutral. Another factor is knowledge or reason to know. The IRS will consider whether you knew or had reason to know of the item giving rise to the understated tax or deficiency as of the date the joint return, including a joint amended return, was filed, or the date you reasonably believed the joint return was filed. If you did not know and had no reason to know of the item giving rise to the understated tax, this factor will weigh in favor of relief. If you knew or had reason to know of the item giving rise to the understated tax, this factor will weigh against relief. Knowledge or reason to know. Actual knowledge of the item giving rise to the understated tax or deficiency will not be weighed more heavily than any other factor. Depending on the facts and circumstances, if you were abused by your spouse or former spouse, or your spouse or former spouse maintained control of the household finances by restricting your access to financial information, and because of the abuse or financial control, you were not able to challenge the treatment of any items on the joint return for fear of your spouse's retaliation, this factor will weigh in favor of relief, even if you knew or had reason to know of the items giving rise to the understated tax or deficiency. Unpaid tax. Depending on the facts and circumstances, if you were abused by your spouse or former spouse, or your spouse maintained control of the household finances by restricting your access to financial information, and because of the abuse or financial control, you were not able to challenge the treatment of any items on the joint return for fear of your spouse's retaliation, then this factor will weigh in favor of relief, even if you knew or had reason to know of the items giving rise to the understated tax or deficiency. Something similar to the previous factor. This factor will weigh in favor of relief if you reasonably expected your spouse to pay the tax liability reported on the return. Unpaid tax. This factor will weigh against relief if, based on the facts and circumstances of the case, it was not reasonable for you to believe that your spouse would or could pay the tax liability shown on the return. Depending on the facts and circumstances, if you were abused by your spouse or former spouse, or your spouse maintained control of the household finances by restricting your access to financial information, and because of the abuse or financial control, you were not able to question the payment of the taxes reported as due on the return, or challenge your spouse's assurance regarding payment of the taxes for fear of his or her retaliation, this factor will weigh in favor of relief, even if you knew or had reason to know about your spouse's intent or ability to pay the taxes due. Reason to know. The facts and circumstances that are considered in determining whether you had reason to know of an understated tax, or reason to know whether your spouse could or would pay the reported tax liability, include, but are not limited to, the following: your level of education, any deceit or evasiveness of your spouse or former spouse, your degree or involvement in the activity generating the income tax liability, your involvement in business or household financial matters, your business or financial expertise, and any lavish or unusual expenditures compared with past spending levels. Abuse by your spouse. For purposes of the equitable relief rules, if you establish that you were the victim of abuse, then depending on the facts and circumstances of your situation, the abuse may result in certain factors weighing in favor of relief when otherwise the factor may have weighed against relief. Abuse by your spouse. Abuse comes in many forms and can include physical, psychological, sexual, or emotional abuse, including efforts to control, isolate, humiliate, and intimidate you, or to undermine your ability to reason independently and be able to do what is required under the tax laws. The impact of alcohol or drug abuse, and the IRS will consider all the facts and circumstances in determining whether you were abused, and could consider the abuse of a child or a family member living with you as abuse of you. Legal obligation. The IRS will consider whether you or your spouse have a legal obligation to pay the outstanding federal income tax liability. For purposes of this factor, a legal obligation is an obligation arising from a divorce decree or other legally binding agreement. This factor will weigh in favor of relief if your former spouse has a sole legal obligation to pay the outstanding income tax liability pursuant to a divorce decree or agreement. Legal obligation. This factor will be neutral if you knew or had reason to know when entering into the divorce decree or agreement that your former spouse will not pay the income tax liability. This factor will weigh against relief if you have the sole legal obligation. If the other spouse has been relieved from liability for the taxes at issue as a result of a discharge in bankruptcy, the IRS will disregard it in determining whether you have the sole legal obligation. This factor will be neutral if, based on an agreement or consent order, both spouses have a legal obligation to pay the outstanding income tax liability. The spouses are not separated or divorced, or the divorce decree or agreement is silent as to any obligation to pay the outstanding income tax liability. Significant benefit. The IRS will consider whether you significantly benefited from the unpaid income tax liability or understated tax. A significant benefit is any benefit in excess of normal support. For example, if you enjoyed the benefits of a lavish lifestyle, such as owning luxury assets and taking expensive vacations, this factor will weigh against relief. If, however, the other spouse controlled the household and business finances, or there was abuse such that he or she made the decision on spending funds for a lavish lifestyle, then this mitigates this factor so that it is neutral. Significant benefit. If only the other spouse significantly benefited from the unpaid tax or understatement, and you had little or no benefit, or the other spouse enjoyed the benefit to your detriment, this factor will weigh in favor of relief. If the amount of unpaid tax or understated tax was small, such that neither spouse received a significant benefit, then this factor is neutral. Whether the amount of unpaid tax or understated tax is small, such that neither spouse received a significant benefit, will vary depending on the facts and circumstances of each case. Compliance with income tax laws. The IRS will consider whether you have made a good faith effort to comply with the income tax laws in the tax years following the tax year or years to which the request for relief relates. If you're compliant for tax years after being divorced from your spouse, then this factor will weigh in favor of relief. If you're not compliant, then this factor will weigh against relief. Compliant with income tax laws. If you made a good faith effort to comply with the tax laws, but were unable to fully comply, then this factor will be neutral. For example, if you timely filed an income tax return, but were unable to fully pay the tax liability due to your poor financial or economic situation after the divorce, then this factor will be neutral. If you remain married to your spouse, but file separate returns, this factor will weigh in favor of relief, even if you are compliant with the tax laws. If you're not compliant with the tax laws, then this factor will weigh against relief. Compliance with income tax laws. If you made a good faith effort to comply with the tax laws, but were unable to fully comply, then this factor would be neutral. For example, if you timely filed an income tax return, but were unable to fully pay the tax liability due to your poor financial or economic situation as a result of being separated or living apart from your spouse, then this factor will be neutral. Mental or physical health. The IRS will consider whether you were in poor physical or mental health. This factor will weigh in favor of relief if you were in poor mental or physical health at one of the following times: at the time the return or returns for which the request for relief relates were filed, at the time you reasonably believed the return or returns were filed, or at the time you request relief. Mental or physical health. the IRS will consider the nature, extent, and duration of your condition, including the ongoing economic impact of your illness. If you were in neither poor physical nor poor mental health, this factor is neutral. The amount of time to request equitable relief depends on whether you are seeking relief from balance due, seeking credit or refund, or seeking both a balance due or credit refund. If you're requesting equitable relief from a balance due, the request generally must be filed within the time period the IRS has to collect the tax if you have a balance due. This period is generally 10 years from the date the tax liability was assessed. But there are situations that can stop the 10 years, like for example, when a taxpayer files for bankruptcy or applies for an offer in compromise, those situations may stop the 10 years. And if there is an action that stops the 10 years, when the time resumes, it will extend the period beyond the original 10 years. If the request for equitable relief is from a credit or refund, generally a request for equitable relief to request a credit or refund must be filed within 3 years after the date the original return was filed, or within 2 years after the date the tax was paid, whichever is later. However, you may have additional time to seek a credit or refund if you live in a federally declared disaster area or you're physically or mentally unable to manage your financial affairs. If you're requesting equitable relief from both a balance due and a credit or refund, then the time period for credit or refund, which is either the 3 years or 2 years that I just explained, will apply to any payments you have made. And then the time period for collection of a balance due, which is a 10-year time frame, will apply to any unpaid liability. How to request relief? You have to file a form, which is Form 8857, and it should be filed as soon as the taxpayer becomes aware of the liability for which the taxpayer believes only the other spouse should be held responsible. The request must generally be filed no later than 2 years after the date on which the IRS first attempted to collect the tax. Tax court review. After you file the Form 8857 with the IRS, you may be able to petition the United States Tax Court for review if the IRS sends a final determination letter regarding your request for relief, or you do not receive a final determination letter from the IRS within 6 months from the date you filed the Form 8857. This will conclude my presentation. So if anyone has any questions, you can just type it in the chat or.
Awesome. And, for the folks who are still on, thank you so much for being here. I know there's so much information, and really this type of training, is the type of training that we are always very excited to have in the training initiative, because it is practical. It's, not just a general overview. It's something that folks can really take into their practices, and helps them be more competent advocates in these subjects and fields that, we don't necessarily get a lot of training on. And maybe no one's touched tax or business entities since the bar, like me. So, I can't thank you both enough for all of this juicy and important information. And I know that the audience is appreciative as well. I don't see any questions in the chat right now. I'm very good at taking up airspace and letting folks get their time to write anything in that they want to. So if you have any last minute thoughts, folks, please feel free to drop it in. In the meantime, I am going to say that I put the CLE code into the chat. That CLE code is 2305 146, N as in Nancy. And of course, that CLE code will be sent to you all along with a copy of this recording. And again, that email will come from Zoom, but you can always reach out to me if you don't receive it directly. And something that did come in through the chat, affirmations. Somebody saying, thank you so much. This will allow me to expand a bit more to my clients. And that's how I think a lot of the folks on this call feel. They don't want to approach a tax issue or a business issue when it pops up in their family law case or their dissolution of marriage and say, I don't know what to do. So now they have a foundation, and I can't thank you both enough for taking the time to teach us. And with that being said, with no other questions in the chat, I know you both have talked enough today. Is there anything else that you'd like to say before we sign off on this lovely Friday? Nope.
Thank you for the opportunity.
Yes, thank you for having us. It was a pleasure.
My absolute pleasure. Thank you for joining the statewide training initiative, for all that you do, for our community and in our education in our law school and for our low income clients. And I would love to be able to rope you both into another training at some point if I think about it. But for now, I'll let you enjoy your weekend. Thank you both, and everybody have a great rest of your day.
Have a good one.
Bye.
Bye-bye.